The interpreter has not been sworn yet, Your Honor.
Good morning. This is Judge Gibson. If you could please raise your right hand to be sworn.
Do you swear to translate from Spanish to English, English to Spanish, truthfully in these matters here today?
Yes, I do. Theodore Leal, certified court interpreter.
Thank you. If you could please connect with the headset.
The interpreter is connected now, Your Honor. Thank you.
Thank you. Sir, please tell me your name.
Julio Sierra Torres.
Julio Sierra Torres.
Good morning, sir. You're here in 21 CF 5928 because a capias was issued for your arrest for failing to appear for arraignment on charges of domestic battery by strangulation and battery domestic violence. There's no bond authorized on that capias. I'll appoint an attorney to represent you. Good luck, sir. It's a barcode for the court reporter so that they know it's the next case. I don't know why. All right, so then this is your order. The clerk just made that. So see, it stated no bond. Those are his charges. If see later, we'll put conditions. So you have to check that and then you sign it. Exactly. Yes. So.
Hey.
Good morning, sir. Please tell me your name.
Juan Manuel Aguilar Villanueva.
Juan Manuel Aguilar Villanueva.
Sí.
2019 MM 5632. You're here because a capias was issued for your arrest for failing to appear for a court date on a charge of domestic battery. The bond authorized is $500. I'll appoint an attorney to represent you. All of your original bond conditions will still be in place, sir. You can't have any contact with the victim. You can't possess a weapon, firearm, or ammunition. Do you understand? All right, good luck, sir. You'll have the probable cause affidavit. Right. Yeah, you'll have the whole of it. Yeah, I know. All right, sir, please tell me your name.
Antonio Quiroz.
Antonio Quiroz.
You're here in 21 MM 7650, charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Give me one moment. There's your front page. And then that's the body. So that's how you determine. That's what you'll have for every case. All right, sir, at this time, your bond conditions are you can have no contact with the victim. Do you understand what no contact means?
Sí, sí.
Yes. Yes.
I'm going to order you must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand?
Okay.
Okay.
You cannot possess a weapon, firearm, or ammunition. All right, good luck, sir.
The bond.
I'm sorry?
The bond amount.
$500. So they'll tell you. And he had no history. So I see. No contact. No weapon. They return one point of law enforcement. Please tell me your name.
Valerie Rivera Ramos.
Alci Rivera Ramos.
You're here in 21MM 7662, charged with battery, domestic violence, and criminal mischief. At this time, I'll appoint an attorney to represent you. There is probable cause. Your bond is $500 on count 1, $100 on count 2. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Sí, pero ¿y mi hijo? Mi nene. Él tiene mi nene.
Yes, but how about my kid? Who has my kid?
I'm sorry?
Who has my
Mi
kid?
nene.
How about my kid? He has my kid.
All right, hold on one moment.
Y él nunca ha tenido mi nene.
He's never been in care of my kid.
Y
Great, so you're saying the victim in this case has your child right now?
Sí.
Yes.
All right, so you're going to have to talk to your attorney about what to do with that. I'm going to order that you must comply with any plan set in place by DCF, and you can't have any contact with the victim right now, but you can have a relative or a good friend help arrange the drop-off of your child. But that has to be in compliance with any plan that DCF sets in place. Do you understand?
Okay.
All right, you must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. You can't possess a weapon, firearm, or ammunition. Do you understand?
Sí.
Yes.
All right, good luck, ma'am.
And Your Honor, if Your Honor could please repeat the case number one more time.
I'm sorry, I can't hear you. What?
If Your Honor could repeat the case number one more time.
Just a moment. 21MM 7662.
Thank you, Your Honor.
So she has to quarantine.
Because DCF was so I don't. Is that all we have for Spanish this morning?
Yes, ma'am.
All right, that's all we have for the interpreter at this time. Thank you.
Very welcome, Your Honor.
Yes. Yeah, so for interpreters, it's call interpreter. That's easy. And then for video conference, if you have, like you might have an attorney who wants to show up virtually, you hit video conference and go in that way. It should be similar to downtown. Right. That's the record. Good morning. Please tell me your name.
Burrows.
This is 21 CF 14064. I see that it was reset yesterday, Counselor.
Yes, Your Honor, may I approach?
Yes, please.
I was able to obtain a new affidavit from the law enforcement officer. I have already provided it to the
Thank you. Give me one moment. I need to read this. All right, thank you, Counselor. Having reviewed the affidavit, there is probable cause here, sir. You're charged with grand theft of a motor vehicle, battery, domestic violence, and criminal mischief, damage greater than $1,000. Were you appointed yesterday, Ms. George?
We were, Your Honor. Just for, when setting the bond, I would ask you to consider, I was here yesterday. The victim did testify that she does allow him to use the vehicle and that he should not have been charged with the grand theft. She did admit she was upset at the time. So I just wanted you to take that into consideration when setting the bond amount for the grand theft auto, Your Honor.
All right, thank you. I appreciate that.
I thought bond was already set yesterday on 1 at 2,000 and 3 at 150, and we only needed a bond as account 2. However, I may be incorrect.
Well, when I spoke to, Judge Bain did set the bond, but yesterday, we did not know how high the bond was going to be on the battery. So he said you could adjust the bonds today, Your Honor.
But after the victim testified in front of Judge Bain, he set the bond on count 1 at $2,000?
Yes, Your Honor. He did not, again, we didn't have the information for the battery or anything to that effect because I brought up the same issue. And he said his response was that you could adjust the bond once you decide what the bond was going to be on the battery. Because I don't know how high it's going to be and if he would. I asked for it to be treated as a subsidiary, but he said he wanted to wait to get the information for the battery, Your Honor.
Your Honor, state's concern regarding bond is he is a fugitive as of 2021 and has significant out-of-state history, I believe out of Michigan. So I'm unsure about his community ties.
I don't know where the fugitive came from.
Information comes from the fugitive. And
I do see that with an extensive criminal history.
so the purpose of bond is to make sure they come back to court. They have out-of-state history, and he's already been linked, obviously, especially to his determination.
All right, I am going to treat that as a subsidiary. So the bond will be $100. With special conditions, you understand you can have no contact with the victim.
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. Were you living in this same place?
No, ma'am.
All right, you can't return to her residence for any reason, be within 1,000 feet of her residence or of her place of employment. Do you understand? All right, good luck, sir.
Thank you. I appreciate you.
I'm staying the other bonds.
Okay, so you're going to treat the battery at 100?
Right,
Okay, thank you.
but then staying the others. Do you need this police report? Yes, please. Sometimes I do, sometimes I don't, depends on the history. Please tell me your name. Sir? Good morning. Can you tell me your name?
Hunter.
Are you okay, sir?
Danny Hunter.
All right, Danny Hunter, thank you. It looks like you're here in 21 CF 13779, charged with second-degree murder. Mr. Hunter, a warrant was issued for your arrest, which means another judge has already found probable cause in this case. I'm going to appoint an attorney to represent you. Does the state wish to be heard?
Yes, Your Honor. Given that he's charged with an F1 that's punishable by life, state's asking that you hold him no bond pending an Arthur hearing.
Any response from the defense?
No, Your Honor, we reserve the right to have an Arthur hearing.
All right, at this time, sir, you'll have no bond on this charge. However, even while in custody, you can have no contact with the victim's family members. Do you understand that? All right.
I don't think he's all here, Your Honor. I'm sorry.
All right. At this time, I'm also going to revoke his out-on-bond case, 20 CF 8789 or 21. The way it's written, it's difficult for me to tell the case number. But I'm going to revoke that at this time. All right, sir, stay in touch with your attorney, okay? Good luck.
Your Honor, for the record, I believe it was 21 CF 8789.
Thank you. Hold on one second, I had the record muted. Robert Mosier is, all right, Ms. George, I'm not sure if you were appointed yesterday, but I'm going to appoint you today.
Yes, Your Honor, I'll waive the appearance.
I'm sorry, his behavior again?
Yes. So his bond will be $500 with a no return to the scene. Please tell me your name.
Rick Cooper.
21 CF 14086. You're here charged with domestic battery by strangulation and battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $5,000 on count 1, $500 on count 2. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. Were you two living together?
Yes, ma'am.
All right, I'll order that you must maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand?
Yes, ma'am.
And at this time, I'm revoking your out on bond cases, 21 CF 12684 and 21 CF 13830. Good luck, sir.
On one of them, Your Honor, I don't believe an information was filed, just for the record.
Okay.
The 2021 CF 126840.
Okay, thank you.
On the,
But he's still revoking. I just wanted to.
Did you want to be heard, Ms. May?
You need Cooper back?
no, Your Honor, that case, the arrest was 9/23. We have not filed on it yet. I believe we're still waiting on FDLE.
All right. Sir, please tell me your name.
Javon Jones.
21 CF 14088. You're here charged with battery domestic by strangulation and battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $5,000 on count 1, $100 on count 2. With special conditions, you can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. You cannot return to her residence for any reason or be within 1,000 feet of her residence or place of employment. Do you understand? All right, good luck, sir. Please tell me your name.
Jonathan Marino.
21 CF 14109. A warrant was issued for your arrest, charging you with false imprisonment, battery, domestic violence, and petty theft. Another judge has already found probable cause. I'll appoint an attorney to represent you.
And Your Honor, I'm
I
not
have an attorney, ma'am.
Oh, you do?
I do.
What's your attorney's name?
My mom just hired him yesterday, or the day before.
All right, so you don't want me to appoint an attorney to represent you at this time?
No, I have one.
All right, then I'll withdraw that. As a friend of the court, though, Ms. George, was there something you wanted to say?
Oh, no, Your Honor. I was just, well, yes, I was going to say that I was not able to see the facts. I was unsure if you were able to see the facts of that.
I am not. I don't have them in the court file.
Okay.
Does the state have it?
I do not, Your Honor.
All right. I'm going to change the bond. Your bond on count 1 is $5,000, count 2 is $1,000, and count 3 is $150. Your bond conditions are you can have no contact with any victim, witness, or co-defendant in this case. Do you understand what no contact means?
Yes, thank you very much, ma'am.
You can't possess a weapon, firearm, or ammunition. You can't go within 1,000 feet of the victim's residence or place of employment. Good luck, sir.
Thank you very much.
Yes, and the do not return. Please tell me your name.
Darren Phillips.
21 CF 14110. You're here charged with false imprisonment, dating violence, and battery, dating violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $10,000 on count 1, $500 on count 2. With special conditions, you can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. Were you two living together?
Yes, ma'am.
All right, you cannot now. I'll order you must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. Do you understand?
Yes, ma'am.
All right, good luck, sir. Please tell me your name.
Rachel Rentz, R-E-N-T-Z.
Thank you, ma'am.
You're welcome.
21 CF 14111. You're here charged with child abuse and 2 counts of battery, domestic violence. At this time, I'm going to appoint an attorney to represent you. There is probable cause. Does the state wish to be heard on bond?
Your Honor, she has a very short criminal history that I see. She does have a prior violent arrest. However, given that a child was involved, alcohol was involved, and there was an independent witness, they would just ask for a reasonable bond, given the nature of the offenses and that a child was involved.
All right, anything, Ms. George?
Your Honor, I just ask that you consider her community ties. She's been in the Orlando area for over a year, and her limited criminal history. I think her last conviction was in 2004.
All right, ma'am, your bond on count 1 is $5,000. Counts 2 and 3 will be $250 each. With special conditions, you can have no contact with the victims or any witness in this case. Do you understand what no contact means?
Yes. Yes.
You can't possess a weapon, firearm, or ammunition. You must comply with any plan set in place by DCF. You can have no unsupervised contact with any minor child under the age of 18. You can't possess or consume any alcoholic beverages, and you'll be subject to random alcohol screens while out on bond. Good luck, ma'am. Please tell me your name.
Sebastian Steve, ma'am.
Good morning. You're here in 21 CF 14112, charged with aggravated assault with a firearm and possession of a firearm by a convicted felon. At this time, I'll appoint an attorney to represent you. Ma'am, did you wish to testify this morning?
No, ma'am. I don't feel no threat, and I have an attorney for him.
What was the first thing you said?
I got him attorney, and I don't feel like I'm a threat. Like he's a threat.
All right, so if you want to say anything to me like that, you need to be sworn in.
Oh, okay.
So raise your right hand to be sworn.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, ma'am, please tell me your name.
Hyena character.
All right. And let me ask the prosecutor, do you have any questions for her, Ms. May?
Briefly, Your Honor.
All right, go ahead.
Miss Character, you said you're not afraid of Mr. Skyfe?
No.
Has anything like this ever happened before? If anything like this ever happened again, and if you did feel threatened, would you feel comfortable calling 911?
Oh, yes.
Was that a yes?
Yes.
Do you believe drugs or alcohol were involved in this incident?
No.
And do you want to have contact with him while this case is pending?
Yes, I'm his baby mother.
Okay, thank you. That's all I have, Your Honor.
All right, and you said you hired an attorney to represent him? I need you to answer out loud because we're
Yes,
making a
ma'am.
record. Okay, thank you. See, I can see your head nodding,
Oh.
but the record won't know that, so.
Okay, I'm sorry.
That's okay, that's why I had to ask. Do you know the attorney's name?
It's Nehemiah.
All right. So, Mr. Scaife, if an attorney has already been retained to represent you, do you want me to have the PD represent you right now, or do you want me to vacate that order and you can just rely on Ms. Character's representations that you have an attorney?
I'm confused. I don't know what would be my best option. Okay.
I'm gonna give you a moment to talk to the public defender.
Your Honor, oh, sorry.
Go ahead.
Your Honor, I would ask that you not appoint us, being that they have already retained an attorney, and I did speak to him about it.
All right, so I'll vacate that. No public defender.
Your Honor, when setting bonds, it would just have you to take into account his history. He does have a prior ag assault with a firearm, as well as a carjacking with a firearm from 2005, and then he also has a 2012 carrying a concealed and possession of a firearm by a convicted felon.
And that, as a friend of the court, Your Honor, I just would ask that you consider he has 0 failures to appear, and that last conviction was in 2013 for possession of cannabis.
All right, thank you both. And thank you, ma'am, for coming. You can stay right there till I'm done with the case. All right, sir. Your bond on count 1 will be $5,000. Your bond on count 2 will be $1,000. At this time, you can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. Did the police confiscate this weapon, Miss May? Does it say that?
No.
I'm not sure, Your Honor. I remember the affidavit said that Miss Ingram came outside and she was a witness and she had the firearm, and it was submitted to a crime scene investigation. So yes, Your Honor, the firearm was confiscated.
All right. I'm ordering that you maintain a separate residence, sir. I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim, and you also can't have any contact with the witness in this case. Do you understand?
We don't live together. I'm sorry.
You don't live together?
No, that's his house.
Okay, so there's no reason for you to go to her place to get belongings?
No,
Okay,
ma'am.
then strike that. I'll just say he's not allowed to go to the victim's residence. Yes. And the one-time return he doesn't need. Okay, all right. Thank you, sir. Good luck. Thank you for coming, ma'am. Good luck.
Thank you.
Good morning. Please tell me your name.
Michael Anthony Sotelo.
21 CF 14084. You're here charged with domestic battery by strangulation and battery domestic violence. At this time, I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $5,000 on count 1. $500 on count 2. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. Were you two living together?
Yes, ma'am.
All right, you can't now. I'm going to order that you must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. Do you understand?
Yes, ma'am.
All right, good luck, sir. Yes.
Your Honor, my client is on Social Security disability. He does qualify for pretrial release, so I would ask that you consider reducing count 1 and placing him on pretrial release. He's been in the Orlando area for over a year, and it looks like he has no history here, but the last conviction out of state was in 2016. So I just asked for pretrial release in conjunction with a lower monetary bond on count 1.
All right, what says the state?
Your Honor, he does have a fairly lengthy out-of-state history. The state has no objection to put him on PTR with bond pursuant to the statute.
All right, sir, I'm going to place you on pretrial release and require that you post a monetary bond. However, I'll reduce that amount to $2,500 on count 1 and $100 on count 2. All of the same conditions still apply. Do you understand?
Yes, ma'am.
All right, good luck, sir.
PTR. Bond. The code is PTR. The code is CRC. So that's why bond 0 goes in the PTR stack. So there's your code.
All right, please tell me your name.
Yeah, Williams.
21 CF 14113. Sir, you're here charged with battery, domestic by strangulation, battery, dating violence, and criminal mischief. I'm going to appoint an attorney to represent you in this case. Ma'am, did you wish to testify?
I got something to say.
All right, raise your right hand, please. Sir, you look at me during this time. Thank you.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
I'm going to ask if the state has some questions for you.
Yes, Your Honor. Good morning, ma'am. Can you please state your name and spell your last name?
Evelyn Dubison, Dubiusson.
Thank you. And what is your relationship to Mr. Williams?
Ex-girlfriend.
Are you afraid of him?
No.
Has anything like this ever happened before?
No.
If anything like this ever happened again, would you feel comfortable calling 911?
Yes.
Do you believe drugs or alcohol were involved in this incident?
No.
And do you want to have contact with him while this case is pending?
Yes.
All right, thank you. Is there anything else you'd like to tell the court?
Yes. I wanted to drop the charges.
All right, so what's happening now is the state of Florida is prosecuting Mr. Williams for committing a crime against the state of Florida. So you're going to have to talk to the state of Florida about that because they make the decision as to whether they're going to charge him.
Okay.
And let me ask Ms. George, did you have any questions for this witness?
No, Your Honor.
All right, thank you. Ma'am, were you trying to say something else?
Yes, I want to say one more thing. He's not a threat to me at all. I was just letting him know I had damaged his property first for him to do what he did. So I kind of started the whole thing. And I was just out of anger. That's why I called you guys. But I kind of started everything because I damaged his property.
All right, thank you. All right, sir, I reviewed the affidavit. There is probable cause here. Your bond is $5,000 on count 1, $100 on count 2, and $100 on count 3. With special conditions, at this time, you can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. Do you have any belongings in her home?
Yes.
All right,
I don't know. I don't know. I don't want it.
No? So you don't need to return one time to gather anything? Okay, then I'm not going to order that. I'll just order that at this time you have no contact with her.
I can look down.
All right. Good luck, sir. Good luck, ma'am. Thank you for coming.
Your Honor, the only condition was no contact?
No weapons, firearms, or ammunition. Are there any other conditions the state would request?
No, Your Honor.
Good morning. Please tell me your name.
Rod Woods Jr.
21 CF 14114. Sir, you're here charged with improper exhibition of a weapon or firearm, carrying a concealed weapon, and battery. I'm going to appoint an attorney to represent you in this case. There is probable cause. Give me one moment.
Your Honor, if you don't mind, Pretrial, do you know when the DOC release was? It got cut off on my form. 11/1.
07.
So I don't have any of that information. I have nothing. No criminal history. See. Because when they ran it the first time, they didn't have that information. It's just what happens. But
Yes, 2007.
Thank you.
all right, does the state wish to be heard on bond?
Your Honor, state, we just asked you to take it. He has a rather short criminal history. However, given the nature of the criminal history and given the nature of the charges, I'll just have you take into account that. And we don't have a victim to testify here today.
Your Honor, I would just ask that you consider that was from 2007. Since then, it does not appear he has been in trouble, and he also has been in the area for over a year.
All right, sir, your bond on count 1 is $5,000. Count 2 is $1,000. Count 3 is $1,000. With special conditions, you can have no contact with the victim or any witness in this case. Do you understand what no contact means? You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. You can't possess or consume any alcoholic beverages. Were you two living together?
No, ma'am.
Okay, so I'll just order. Are you living at 2121 Rogers Avenue?
Yes, ma'am.
But she doesn't live there?
No.
All right, I'm not going to order a do not return. Okay, good luck, sir. No maintain because they're not living together. So just the no contact and no weapons. Please tell me your name.
That's a Brown.
21MM7636. You're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500.
Your Honor, we have a witness.
Thank you. Ma'am, did you wish to testify today?
Yes, ma'am.
All right, thank you.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
I'm going to let the prosecutor ask you some questions.
Yes, ma'am.
Good morning. Can you please state your name for the record and spell your last name?
Lysandra Dominique Collier, Collier.
Thank you. And what is your
Ma'am?
relationship to Ms.
Just a moment, Miss May. Ma'am, I need you to look at me or over here. Don't look at the witness. Thank you. Go ahead, Miss May.
And what is your relationship to Ms. Brown?
She's my ex-girlfriend.
Are you afraid of her?
Yes.
Has anything like this ever happened before?
Yes.
Approximately how long ago would you say the last time was?
It was like 2018.
Okay. Do you want to have contact with her while this case is pending?
No, but she does have clothes at my house and like her purse with her like ID cards and debit cards.
Understood. We can make sure she has a condition to be able to come get that.
Okay.
Do you believe alcohol or drugs were involved in this incident?
She was drinking alcohol.
Okay. And if anything like this or anything more severe ever occurred in the future, would you feel comfortable calling 911?
Yes, ma'am.
All right, thank you. That's all I have, Your Honor.
All right, any questions from the defense?
No questions, Your Honor.
All right, thank you, ma'am. Was there anything else you wanted to tell me?
No, I just want her to get help because we've been dating on again, off again 6 years, and this has been a repeated pattern. We just had a situation with a relative that I had living with me, my cousin. So being that that situation happened, I guess it kind of triggered her mental for her to react the way that she did towards me. But I just want her to get some help mentally. She needs to get some type of mental help for her anger and whatever she's going through, because I've tried to help her so many times. I wash my hands with it. I can't help her anymore.
Well, I appreciate that, and unfortunately, I don't have jurisdiction to order any kind of treatment for her, but I'll ask Ms. George if you can take some notes about that for your colleagues, and maybe they can help her find some resources.
Yes, Your Honor.
All right, so at this time, Ms. Brown, your bond is $500. With special conditions, you can have no contact with the victim. Do you understand what no contact means? I didn't hear you.
Yes.
Thank you. You can't possess a weapon, firearm, or ammunition. I'll order you must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. You also can't possess or consume any alcoholic beverages, and you'll be subject to random alcohol screens. Good luck, ma'am. Good luck, ma'am. Thank you. Please tell me your name.
Damian Carpenter.
21MM7659. You're here charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. What is this release on 10/1/2021?
It's DOC release.
All right. All right, sir, your bond is $1,000. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. Do you understand?
Yes, ma'am.
Are there any other conditions the state would request?
No, Your Honor, I didn't see any other conditions.
All right, good luck, sir. Please tell me your name.
Dwayne Johnson.
21MM7649. You're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. You can't return to the victim's residence for any reason. Were you two living together?
No, I got my own place.
All right, so you don't need to go back to her place to get any of your belongings.
I mean, I just call. I got one time with the police, so it's all good.
Wait, say that one more time.
Yeah, don't I got one time I can call the police to none?
Well, that's what I'm asking. I can order that.
Oh, yeah, thank you.
Is that what you need?
Yeah.
Okay, then I will order that you must maintain a separate residence, and I'll allow one-time return with law enforcement.
Thank you.
Yes, sir. All right, good luck, sir.
All right, y'all have a blessing.
No. There was conflicting information about whether they lived together, so initially I thought they didn't. Please tell me your name.
Jonathan King.
21MM7657. You're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Sir, your bond is $500 with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Yes.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. Any other conditions the state would request?
Your Honor, I believe there was a allegation of alcohol.
All right, sir, I'll further order that you can't possess or consume any alcoholic beverages, and you'll be subject to random alcohol screens. You understand?
Yes.
All right, good luck, sir. Good morning. Please tell me your name.
Jacob Lowry.
21MM7637. You're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Ma'am, did you wish to testify?
Yes.
Please raise your right hand and be sworn.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Go ahead, Ms. May.
Good morning, ma'am. Can you please state your name and spell your last name for the record?
Miranda Gomez, Gomez.
And what is your relationship to Mr. Lowry?
He's my fiance.
Are you afraid of him?
No.
Has anything like this ever happened before?
No.
If anything like this ever occurred in the future, would you feel comfortable calling 911?
Yes.
Do you believe drugs or alcohol were involved in this incident?
Alcohol.
Do you want to have contact with him while this case is pending?
Yes.
Is there anything else you'd like to tell the court?
I just want to say that I was saying to the police that this was not a big deal. Like, I was arguing with him outside of a car. We were at Universal Studios. We just got out of Halloween Horror Nights. Like, the witness herself was in an abusive relationship, and she was the one that was like, it's just going to get worse from here. And she was very insistent that she was just putting her personal horrible experience and trying to save me from that. But this is not the case. This is not what happened. Like, this was all a misunderstanding. Like, we're on vacation. We live in Jacksonville. Like, we're supposed to be enjoying ourselves at a resort right now. And now, like, we're supposed to leave tomorrow. Like, I don't understand. Like, this all got blown out of proportion.
All right, thank you, ma'am. Ms. George, any questions?
No, Your Honor, but I would ask for a no hostile contact order given the witness's testimony and his limited criminal history.
What says the state?
No, I'll leave it within your discretion. The allegation, it looks like, was mostly pushing and pushing into a vehicle. He does have very limited criminal history. And given the victim's testimony that she's not fearful and would like contact, state has no objection.
All right, thank you, ma'am. I appreciate you coming today and testifying. I'll tell you that I'm a little bit concerned with the things that I'm reading in this affidavit. So at this time, Mr. Lowry, your bond is $500, and I'm going to order that you can have no contact with the victim. You can't possess a weapon, firearm, or ammunition. Do you still have belongings at Universal Studios?
No, I believe it's all in the car.
We just got here. We just got to Orlando. Like, this was all blown out of proportion. Please, Your Honor.
So, ma'am, I understand that you're saying that, but I'm concerned because I'm reading in the affidavit the statement of a couple of independent eyewitnesses. The law enforcement officer says that he noticed abrasions on your person.
It was by my purse. I had the keys I was being stubborn, ma'am. It was me.
Ma'am, in the state of Florida, someone can't shove you into a car repeatedly. That's a crime.
The witnesses, like, he is larger. I'm petite. We're literally a foot apart. Like, all they saw was a big man pushing a little girl. It was not that big of a deal, I promise.
Right, but that's very concerning, ma'am. It's very concerning. And part of the concern is the size differential. So I think anytime anyone touches another person against their will, it's very serious. And I think when the size differential is this great, it's even more concerning for the court. But listen, here's what this means. I don't know that the state's even gonna file this charge. That's up to the state of Florida. So I don't know what they're gonna do with it. At any time in this case, another judge can change my order. So what I'm going to tell him is, I've appointed an attorney to represent you. She's gonna give you a piece of paper with a phone number. You need to call that number right away. You have bond, you can bond out today if you want. And you can ask that attorney to file a motion in front of the trial judge to amend my order and allow you to have peaceful contact. I think sometimes in situations like this, it helps everybody if we just take a breath, just take a step back, y'all just have some time to yourselves. And then when another judge changes this, you can have contact again. This isn't forever. And like I said, I don't know what the state's gonna do with the case. So if they decide not to even file it, then he won't have anything to worry about.
Okay.
But for this moment, that's my order. So I just want you guys to take a break. Just don't call her, don't text her, don't contact her on social media, right? So you're gonna go separate for right now. Yes, sir, hold on. Before you ask anything, I wanna make sure you understand everything you say is being recorded and can be used against you later. You understand?
Your Honor, they both came together. All of his belongings are in the vehicle as well. If we look, the witness did testify that alcohol played a role in this. I believe if you issue the no hostile contact order and he's not allowed to drink any type of alcoholic beverage and he'll be subject to random alcohol screen, that would be sufficient to prevent this from happening again. His history shows he does not have a violent history or any type of indication that he's a violent person. And I would just ask that because of that, you do give a no hostile contact order. Even place him on pretrial release, Your Honor. If he violates your court order, he can be brought back here and held at no bond. But I do think that this is a situation where they should at least be given a chance to abide by the court order, given he doesn't have any violent history. And the only thing he had was a driving while license suspended in 2015. And I think the biggest thing is they rode together. I don't know how. They're on vacation.
I understand, Counselor, but it's concerning to the court that this happened in public. We don't know what happens in private. I'm concerned. There are eyewitnesses who saw this, and the marks on her body, the law enforcement officer says, correspond with the statements of the witnesses of what he did to her. So that's why I'm concerned. Miss Ramshaw? No, what's your last name?
Gomez, Your Honor.
Gomez, Miss Gomez. I've already told you my concerns. Given all of that, do you still want me to allow him to have contact with you?
Yes, ma'am. May I say something?
Yes, ma'am.
I do appreciate the witnesses that came that would help someone, a random stranger, but she did tell me she was personally in an abusive relationship and she was fearing for me. So I understand her concern, but this is not our case at all. She was fearing for something of her own personal life.
Ms. Gomez, I think if I were in your shoes, I would be taking that to heart and really consider that a stranger was willing to go out of her way to try to help save me because she sees warning signs that maybe you're not seeing. However, based on your testimony here today, and I see that Mr. Lowry has no violent history, I'm going to amend my order. I'm going to place you on pretrial release and require that you post a monetary bond. It's still going to be $500. I'm going to allow you to have peaceful contact with the victim, but you understand peaceful contact means no hostile contact. You can't push, you can't shove, you can't drag her, you can't hit her. Don't even raise your voice. Do you understand that? And you understand that you're the person with everything at risk here. Because if you get arrested, you can be held at no bond for violating my order. You understand?
Yes, ma'am.
You can't have any contact with any of the witnesses in this case. You can't possess a weapon, firearm, or ammunition. You can't possess or consume alcoholic beverages, and you'll be subject to random alcohol screens while on pretrial release. You understand?
Yes, ma'am.
All right, good luck, sir. Good luck, ma'am.
Thank you.
Thank you for coming. Please tell me your name.
Linnell,
Her.
First name, last name, Mary Segan.
21MM522. Good morning, ma'am. You're here charged with battery, domestic violence. I'm going to appoint an attorney to represent you. There is probable cause. Sir, did you wish to testify?
yes,
Please raise your right hand.
You swear to tell the truth, the whole truth, and nothing but the truth?
yes.
May I inquire?
Yes, please.
Good morning, sir. Can you please state your name for the record and spell your last name?
First name Linnell, last name Marasigan, Marasigan.
Thank you. And what is your relationship to Miss Lovely Marasigan?
My wife?
Are you afraid of her?
No,
Has anything like this ever happened before?
yes.
Approximately how long ago would you say the last time was?
Wednesday, this past Wednesday.
Do you believe drugs or alcohol were involved in this incident?
No,
If anything like this or anything more severe ever occurred in the future, would you feel comfortable calling 911?
yes,
And do you want to have contact with Miss Marasigan while this case is pending?
yes.
Is there anything else you would like to tell the court?
Yeah, I believe that she had physical and psychological trauma at a young age, a child that hasn't ever been looked at by a professional. So a lot of her anger and her emotions haven't been worked with, and I've tried to work with her in so many ways, listen and talk, and I've referred her to counseling, but she doesn't. She refused. So I'm hoping or something or a way that we can get her in there, because if we can get there, this will maybe help and improve her in some way somehow.
All right, thank you,
And
sir.
like I said, she's a good mother. You know, she takes care of my kids, our kids together, and it's just that when situations like this, when there's good days, it's good days, but when it's bad days. And all I want is just to make sure she gets help. And
Thank you, I appreciate that. Unfortunately, I don't have jurisdiction to order her into any kind of treatment at this time. However, I'll again ask Ms. George if you can make some notes for your colleagues. Maybe they can direct her to some resources. And then I believe that the state does have programs, and they have things like counseling programs, the batterers intervention program, things like that. But I can't do that today. So what I'm going to do, ma'am, is I set your bond at $500. Remind me again, sir, did you say you do or do not want contact with her?
I do, because she has a surgery on, she has a pre-op on November 2nd and then the surgery on November 9th. And I'm normally the one that goes with her and talks to the doctors and things like that and help her and everything, like understand and all that stuff. So I don't know how that plays out or what, and she'll be out of work for 2 months and things like that. And
All right, at this time, I'm going to allow peaceful contact. Ma'am, that means no hostile contact. You can't push him, you can't shove him, don't even raise your voice. Do you understand? You can't possess a weapon, firearm, or ammunition.
What's that?
Are there any other conditions the state would request?
No, Your Honor.
All right, good luck, ma'am. Thank you, sir, for coming. Good luck.
thank you.
Please tell me your name. Ma'am, what's your name?
My name is Rafaela
What's your whole name?
Diana Cunha Barros.
21MM7660. You're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Sir, did you wish to testify?
Yes.
All right, thank you.
He's ready to tell the truth, the whole truth, and nothing but the truth.
Yes.
Go ahead, Ms. May.
Good morning, sir. Can you please state your relationship to the defendant?
She's my fiancée.
Are you afraid of her?
No.
Has anything like this ever happened before?
No.
If anything like this ever occurred in the future, would you feel comfortable calling 911?
Yes.
Do you believe drugs or alcohol were involved in this incident?
I'm sorry?
Do you believe drugs or alcohol were involved in this incident?
No.
And do you want to have contact with her while this case is pending?
Yes.
Is there anything else you'd like to tell the court?
Yes. So we have a kid together, which he's 1 year old. We've been together for about 2 years and a half. And I didn't actually see the police report, but this got out of hand by a lot, I believe, because what happened is we did have a discussion a couple days ago. She found out I was texting another girl, and she found out, so we went out yesterday and we had a discussion about it. And she pushed me into the bushes. That was it. And then somebody called the police, and they arrested her for that, which seems a lot out of hand. And we're in the process right now of getting documentations. We're immigrants. We're from Brazil. I've been waiting for 6 years with a lot of time. And with this charge, if she gets a charge for battery and assault for simply like pushing me on the bushes, I know everybody has to take responsibility for what they do, but this seems a lot out of hand. And if she does get a charge like that, I'm not gonna be able to get her documentation. We're not gonna be able to legally immigrate to this country, and I have a kid that's already American with her. This never happened before. I really, really believe that's something that it's just a circumstance that happened. I'm not saying that she doesn't have to. She's not responsible for pushing me. She is, but it's a first-time offense. She never did nothing like that before, and it seems a lot out of hand to charge her with battery and assault and domestic violence for that.
So in the state of Florida, it's a crime to intentionally touch someone against their will. That's the crime of battery, and that's what she's been charged with. So in the police report, the affidavit that I'm reviewing, there is probable cause for that charge. Now, I don't know what the state of Florida is going to do with this later. So they may decide not to charge it at all, but I don't have control over that.
Yes.
So that's up to the state of Florida. So for now, since there is probable cause, ma'am, your bond is $500. I'll allow you to have peaceful contact with the victim. Do you understand what that means?
Yes.
No hostile contact, no yelling, no shoving, no pushing, nothing. You understand?
Yes.
You can't possess a weapon, firearm, or ammunition. And that's all at this time. All right, thank you, sir. Good luck.
I do have a question though, sorry.
Yes.
I don't know how to proceed from there. They give information outside, or like if she has a bond, I can pay the bond and she can leave today. I'm sorry if I have to take the question.
If you go downstairs,
There you
if
go.
you go downstairs, you can speak to them about paying the bond.
Okay. All right. Thank you very much. Have a great day.
Good luck. Thank you, sir. So in the computer, good morning, sir. Please tell me your name.
Bridges.
Thank you. Sir, you have a warrant out of Polk County in case 0044955, charging you with battery, domestic violence, and tampering with a witness. We'll notify Polk County that you're here so they can transport you. In the meantime, I'm going to appoint an attorney to represent you. On the battery charge, you have no bond, and the tampering with a witness, your bond is $1,000. But because the battery is no bond, you won't be able to get out. You understand? Okay, so we'll notify them that you're here so they can come and get you.
Do they have a certain time they?
So technically, yes, we have an admin order that says how long they have, but because of coronavirus, that changed everything, and it slowed down the transportation because they're trying to prevent the spread of COVID-19. So I don't know how long it will take them, but everybody's pretty much transporting pretty quickly now.
I didn't even know I had no warrant. I never been arrested up there.
No, right, because it's a warrant. So I believe what you're saying, but I can't change it because the judge in Polk County has to change this one. So that's why I'm appointing an attorney to represent you. Call that number right away. But you got to go back to Polk County to address it.
So I will still have the same bond there?
Right, you will. So the judge there can change that no bond.
Okay, all right.
Yes, sir.
This one.
That's all I have, so I don't know. CF 193366. Yeah. Yeah.
So you know the warrant, so the other county has to do it.
Yeah.
We can't let him out because they're gonna. So if it is county, there's no bond because.
No, if they have a bond, you give them the bond. But like in this case, because it's a VOP, there's no bond.
Well, you just, it seems to me.
Sir, please tell me your name.
Joseph Vidal Lopez.
All right, in 19 CF 3837, it looks like you have a warrant for violating your probation out of Seminole County on a charge of possession of cocaine. There's no bond authorized on that warrant. I'll appoint an attorney to represent you in the meantime. We'll notify them that you're here.
Thank you.
Good luck, sir. Please tell me your name.
My name is Ricky Kingsley Steven.
Thank you. 21 CF 3108. Looks like you have a warrant out of Osceola County on a charge of lewd or lascivious battery. At this time, there is no bond. I'll appoint an attorney to represent you, and we'll notify Osceola County that you're here.
All right, no problem. Do you mind me asking a question?
You can ask anything you want, but first I want to make sure you understand everything you say is being recorded and can be used against you later. Do you understand?
Yeah, of course. No, I just wanted to know exactly what that the L word you said was meant.
Lewd or lascivious battery.
Yes.
It's a sex offense.
Okay.
So the charge is that you've committed some kind of sex offense, but I don't have the affidavit for that warrant because it's not an Orange County warrant.
Okay. All right. I think that's all the questions I had. But I'm kind of confused because I've never really had any criminal record in my life, and I feel as though I'm just being wrongfully accused, or my name is just being put out there. Because I am a musician and I am an investor. I'm a mentor. I invest in stocks and those things like that. So I'm just kind of confused as to why I'm even in the system to begin with. Because
So a warrant was issued for your arrest, which means that law enforcement likely presented an affidavit to a judge. The judge reviewed the affidavit and issued a warrant charging you with a sex crime on someone under 18.
But that's my thing though. Like,
Your Honor, I have a date of incident of June 19th of 2021, and the alleged victim says she met the defendant on Snapchat at approximately 2:45 a.m. in St. Cloud.
All right, Mr. Stephen, did you hear what the state said?
could you go again?
Can you say that one more time, Counselor?
The alleged date of incident was June 19th, 2021 at approximately 2:45 a.m. The alleged victim's name is Sierra Trudeau, and she allegedly met you through Snapchat.
I don't know nobody like that.
All right, so if you think you have some defenses to the case, you'll want to talk to your lawyer about them, and you can raise them when you get back to Osceola County in an evidentiary hearing, but we can't do that today.
No, it's okay. You guys can say whatever you want, whatever's on file, but I already know I'm good, so appreciate it.
All right, good luck, sir. Please tell me your name. Sir, what's your name?
Paul Salaji.
21
Hard of
CT.
hearing.
Oh, can you hear me? Are you able to hear me?
I can barely hear you.
Okay, they're going to get you a headset.
Yeah, that's what they use.
Okay. How about this, sir? Is that better?
Yes, ma'am.
All right. You're here in 21 CT 46358. A warrant was issued for your arrest.
Stop.
Is it better now?
Barely. A little higher.
All right, sir. Is that good?
Yeah.
All right. A warrant was issued for your arrest out of Brevard County for driving while license suspended. The bond authorized is $500. You can post that if you're able to and bond out.
Yeah,
Or we'll notify them that you're
Can I bond
here.
out from here?
You can.
Okay, my
Or
daughter's willing
they'll
to bond me
transport
out.
you.
The only reason I missed it was,
Don't
Your
talk,
Honor,
don't
was
talk
I
about
was
the facts. Don't talk about.
I'm going to appoint an attorney to represent you. Your attorney is trying to tell you something.
So you have a bond. You have a bond. Do not talk about the facts of the case, okay? So you can post bond from here, okay?
My daughter wants to bond me out.
Yep, so just let your daughter know. You can just let your daughter know. She can bond you.
Let her know.
Mm-hmm.
All right, good luck, sir.
Thank you.
Thank you, Ms. George. Sir, please tell me your name.
Gary Thames.
I don't know if that's the right case number. What case number do you have? Yeah, that's what we have. Okay, so 1214665 CF. You have a warrant out of Pinellas County for violating probation on charges of robbery with a gun or deadly weapon. At this time, there's no bond authorized, and I'll appoint an attorney to represent you. We'll notify Pinellas County you're here so they can transport you. All right, good luck, sir. Please tell me your name.
Luis Bonilla Arroyo.
You're here in 19 CF 3772. A warrant was issued for your arrest, charging you with violating your probation. The allegation is that you failed to report as directed and changed your residence without first procuring the consent of your probation officer, failed to pay the state of Florida, failed to attend and successfully complete the batterer's intervention program. At this time, I'll appoint an attorney to represent you. You have no bond. All right, good luck, sir. Please tell me your name.
Edwin Cintron, ma'am.
Thank you. In 2009, CF, hold on, you have 4 cases. 8804, 9034, 10302, and 17856. You're here for violating probation. Let me pull these up, and I can tell you what the allegations are. That you violated your probation by having unsupervised contact with a child under the age of 18. There are several counts of that. All right, let me see if it's the same in each of these warrants. You have no bond at this time, sir. I'll appoint an attorney to represent you. I'll tell you if there's any new allegations. All right, so it looks like the allegations in all of these warrants are that you had unsupervised contact with minor children, and that violated your conditions of probation.
Yes, ma'am.
All right, good luck, sir.
Thank you.
Sir, please tell me your name.
Welcome to an Econo meeting. You are entering the meeting now.
Jeffrey Hartso.
You are the only participant.
All right, it looks like you have an attorney. We sent him the link for him to appear, but he's not here right now. Can we do the other gentleman first and just give him a minute to see if his attorney appears? All right, sir, please tell me your name.
Keeson Miller.
In 19 MM 659, a capias was issued for your arrest for failing to appear for arraignment on a charge of petty theft. Interestingly, the bond authorized is pretrial release, but we can't do that. So I'm going to change that to no bond because you have 2 violations of probation with no bond. So you'll have no bond on that capias case. And then in 2017 CF 8974, hold on, that's the wrong case. You're here for violating your probation. A warrant was issued for your arrest. There's no bond authorized on that warrant. I'll appoint an attorney in both of these cases. And I'll tell you what the allegations of violation are. It's that you failed to report as directed to probation, failed to pay the state of Florida, made yourself unavailable for supervision, failed to make restitution payments, failed to pay court costs, failed to complete community service hours as directed. Yes.
Thank you, Your Honor.
All right, thank you. So that's,
Your Honor, Mr. Tillman is our last.
all right, let's go ahead and do Mr. Tillman's case, and then we'll come back to Mr. Hartso. I'm just going to give his attorney a few more minutes to appear if we can. Thank you. All right, sir, please tell me your name.
Bernardus Tillman.
You're here in 19 CF 3389. A capias was issued for your arrest for failing to appear on a charge of possession of cocaine. The bond authorized is $500, and I'll appoint an attorney to represent you. And then in 19 CF 3390, you're here for a violation of probation. A warrant was issued for your arrest. I can't get my computer to move. Give me 1 second. I'm trying to get to your file right now. I'm going to appoint an attorney to represent you in that case as well. Oh no, that's the wrong one. It looks like your bond on that case is $2,500. And I'll tell you what the affidavit alleges that you did to violate your probation. You failed to make court cost payments, failed to pay the cost of supervision, failed to perform 50 hours of community service, and failed to undergo a complete driving class. So those are the allegations in that affidavit violating your probation. All right, good luck, sir. All right, Mr. Hartso, it doesn't look like your attorney is appearing today. You're represented by Michael Brown?
Yes, ma'am.
All right, this is 19 CF 16060. Looks like you're here for violating your probation. There's no bond authorized. Hold on one moment. Okay. My assistant just heard from your attorney. He's actually driving and unable to connect to the courtroom, but he says he understands you're being held at no bond, and he thought he waived his appearance, so that's fine. Let me tell you what the allegations are of your violation. That you failed to successfully complete 40 hours of community service as directed and failed to make your court cost payments as directed.
Your Honor,
Yes, sir.
I actually have the paper showing that I actually did complete the community service, and I've got the paperwork showing I did pay all the fines. The fines were paid in August, and this was done October the 20th.
Hold on 1 second. The warrant was signed, looks like October the 14th by, oh, there you go, by Judge Nunez Navarro. I couldn't see it.
And I have my initials showing that I did complete it as well.
Well, that's interesting. That doesn't usually happen. No. I don't usually look at that stuff. All right, can you show that to the state of Florida? Ms. May, can you look at this? And give your thoughts to the court. Mhm.
Your Honor,
Yes, sir.
under the weird circumstances, is there any way I could perhaps ask for a compassionate release or anything like that, or a bond set under these circumstances?
So I'm asking the state to review what you've presented. I'm happy to look at it, but because this warrant was signed by another judge and the affidavit was sworn to by your probation officer, it has some very specific dates in it. I'm not likely to change this warrant and grant you a bond. However, I understand that that's your request. Let me see what the state says after they review it, and then I'll look at it.
Thank you so much.
Yes, sir.
Your Honor, may I approach?
Yes, please. When was the payment made? Well, when does the clerk site say that, though? Oh, it just doesn't say when? Okay. 14. So it came in after the warrant was issued. Mm-hmm. Yeah. All right, sir. Thank you. I appreciate that you brought this information, but what you're going to have to do is you're going to have to take this in front of Judge Navarro, because it looks like from your sign-in sheet that you started the hours. I mean, you did do some in August, and then you started them again on 10/14, then 10/15, 10/18, and 10/20. Judge Navarro signed this warrant on 10/14. And what it says in the warrant is that your probation officer instructed you to complete these community service hours back in 2020. And so several times since 2020, your probation officer told you to do this, and you didn't do it and didn't do it and didn't do it. And then as soon as the warrant got issued, that's when you did it. So what this means is you need Judge Navarro to consider this, and she'll decide whether this is a willful violation or not, and then whether she'll let you out or whether she's going to sentence you. You'll have to have a hearing in front of her.
Now, should I bring, for Judge Navarro, should I bring because I was in the hospital, I had a mild heart attack, and Ms. Campos, my probation officer, also has all of that information as well, including medications I had to take and everything else, and my stay in the hospital. So she's aware of all of that as well, which is part of the reason why I didn't do it until this year, after COVID and my health scare, that I was actually able to. So will I need that information also?
You need to talk to your attorney about that. I can't give you legal advice, but that's why I said Judge Navarro is the one who's going to have to determine if this was a willful violation. I can't do that today, and so I'm not going to change her warrant.
Understandable.
Give your attorney a call.
Thank you so much.
All right, good luck, sir. All right, is the state ready for 33-day motions?
Yes, Your Honor. Susan Furpies, 21 CF 12635.
So who's the move-ups? Foster. Good morning, sir. Please tell me your name.
Charles White.
All right, sir, you're here in 21 CF 14071, charged with fleeing or attempting to elude, reckless driving, and leaving the scene of a crash with property damage. Give me one moment. Sir, I'm going to appoint an attorney to represent you.
Would you repeat that for me?
Sir, I'm appointing an attorney to represent you in this case.
Okay. And the case is? Fleeing and eluding?
Yes, sir. Fleeing or attempting to elude law enforcement, reckless driving, and leaving the scene of a crash with property damage.
Okay.
A warrant was issued for your arrest. So another judge has already found probable cause. Your bond is $100,000 on count 1, $50,000 on count 2, and $500 on count 3. Sir, you can't drive without a valid Florida license, and you cannot operate a motor vehicle. Do you understand?
For how long?
Until another judge changes that order.
Okay.
All right, good luck, sir.
Your Honor, can we bypass Mr. Foster?
Yes.
Your Honor, do you have an affidavit for Mr. Moreno James Yedinson? I don't believe myself or
Spell the last name.
Moreno. Moreno, then James.
If I do, it's in the clerk's system.
I don't have the.
Because I don't have anything paper.
I don't have the affidavit. I don't believe Miss George does either.
No, I don't. I don't know what that.
Is this the CT?
It says it's a traffic, yes, Your Honor.
The DUI?
That's why we.
Who did? Okay.
Oh, that's why we don't have, okay.
Yeah, I do have an affidavit in the court file. Is this interpreter cases?
Yes, ma'am.
Good morning, Your Honor. This is Rafael Barrera, State Certified Court Interpreter. I have been previously sworn.
Good morning. This is Judge Gibson. If you could please connect with the headset.
Certainly, Your Honor. Allow me just a moment to connect and confirm.
See?
Your Honor, the interpreter can confirm the defendant is able to hear through the headsets.
Good morning, sir. Please tell me your name.
Isander Carrión Medina.
Isander Carrión Medina.
You're here in 2018 CF 15637 because a capias was issued for your arrest for failing to appear for court on a charge of possession of cocaine. At this time, there's no bond authorized on that capias, and I'll appoint an attorney to represent you. Good luck, sir. Is that all for Spanish speakers?
Yes, ma'am.
All right, that's the only interpreter case we have today. Thank you.
Thank you, Your Honor. Have a good day.
You as well.
Good morning, Your Honor.
Good morning. Please tell me your name.
Joseph Dyer.
All right, I don't have him. What's he charged with?
He's the out on bond case that was reset.
I don't know what you're talking about. Where would I find him?
I don't either. Just a second.
So, does he have an attorney who represents him?
What is this case about, and what is it?
I have no idea, sir. That's what I'm trying to figure out.
I don't know if he previously had a public defender because it's the FTA case that he came in on, but the bond was ROR.
On the capias, so he saw a judge on 21 MM 51, right?
Maybe on a previous arrest, but he came in on it, he was released ROR. He didn't see a judge when he came in.
Oh, because he was released, because that's what the capia
Yes,
says.
but he
All
had
right.
an out on bond case.
Oh.
That just needs to be addressed, if you want to take action on it or not.
I'd like to resolve this today, because I've already done more than enough time, and I keep getting arrested. I'm like, and I was incarcerated at the time of, the time I was supposed to be going to court. They never sent me to court. That's for the petty theft.
Right, you're not here on that.
What am I here
I mean,
for?
the case number.
It looks like,
Trespass?
right.
I'm already bonded out on that, and I.
Right, so hold on. It looks like what happened is, because a judge issued a capias for your arrest for failing to appear for the battery, petty theft, and criminal mischief, once you were brought to jail on that capias, even though the judge authorized for you to be released on that, the jail is holding you because they say you're out on bond on this trespass case. Hold on a minute.
Your Honor, since he was given an ROR, I would ask that you take no action.
Yeah, I'm gonna take no action on that. I don't even know why it's here, so. All right, I'm taking no action on that case, sir. Good luck.
Are they gonna give me a court date, or are they gonna come back and get me and make me lose another job? I mean.
You should have a court date in all of your cases.
I have Andrew as my public defender on the petty theft thing. He's supposed to give me time served. Okay. I just like to plead out and just get it over with.
You can't do that today, sir. I'm sorry.
I have no problem.
So just call in.
Okay. Thank you. Thank you, Honor.
Good luck, sir. Please tell me your name. 21 MM 7653. You're here charged with battery. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. You can have no contact with the victim or any witness in this case. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You can't be within 500 feet of the victim's residence or place of employment. And at this time, I'm revoking your bond in 21 MM 7421.
Your Honor, I'm not sure if, I couldn't find it in our system, if we were appointed. Since you're revoking the bond, I would ask to be appointed if she does not have an attorney representing her on the out on bond.
All right, I'll appoint you.
Thank you.
It doesn't look like she has an attorney, so.
Okay, thank you.
All right, good luck, ma'am.
You can't bond out. Call the number.
Why not?
Because you were out on bond for committing a criminal offense when you were arrested for committing another criminal offense. So at this time, I've revoked your bond in the, is it petty theft case?
Yes, ma'am.
So you're gonna have to have your attorney file a motion in front of the trial judge to get you a new bond. Good luck, ma'am. Please tell me your name. 21 MM 7652. You're here charged with retail petty theft. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. You can't return to the scene for any reason. Do you understand? At this time, I'm revoking your bond in 21 CT 1793. Good luck, ma'am.
So, it will be the same, sorry.
I revoked your bond in your DUI case. So your attorney's gonna have to file a motion in front of the trial judge to get you a new bond.
Okay. Your Honor, does she have an attorney? If she does not have an attorney on the out on bond, could you just appoint us? I can't, for some of these cases I can't find, so I just want to make sure she's represented since she's at no bond.
Yes, I'll appoint your office to represent her if you weren't already. Please tell me your name, sir.
Vernon Wade Haynes.
You're here in 21 MM 7656, charged with battery. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. You can't have any contact with the victim. You can't return to, does the church have a name?
I can try to find one, Your Honor.
The church located at 2113 South Street. Sir, you can't possess or consume any alcoholic beverages. You can't possess a weapon of any kind, firearm, or ammunition. Do you understand?
Yes, ma'am.
All right, good luck, sir.
It is the South Street Ministry, Your Honor.
Your Honor, we have Mr. Foster present.
Skipped.
What is this?
I need to speak. I need to speak to him. Can we pass him for a second? Yeah.
Okay. I'm gonna do it right now. Thank you. Sorry, Couldn't figure that out fast enough.
Welcome to an Econo meeting. You are entering the meeting now.
All right, who do you have next?
She needs to speak to Mr. Foster, so we have Pius.
Who?
Gabrielle, pronounce your last name.
Okay, I don't know who that is. What is he charged with?
You'll be the,
Neil was next, I think that's.
Neil refused, Your Honor. Tony Neal refused.
Oh, Tony Neal refused. Okay.
You are the only participant.
All right, so that case is 21MO1230 and 21MM7655. I'll find his refusal a willing waiver of his appearance today. His bond is $250 on the MO case, $250 on the MM case. Cannot possess or consume any controlled substances or have contact with any known drug dealers, and I'm appointing the public defender's office. Yes. So what's your name, sir?
Gabriel Paz de Barros.
Got it. 21MM7650. Sir, you're here charged with retail petty theft. I'm going to appoint an attorney to represent you in this case. Give me one moment.
I can't have an offer today, Your Honor.
I don't know. Does the state have an offer in this case?
No.
Mr. Perez de Barrios? No,
Right.
Your Honor, it's potentially enhanceable.
All right. So the state doesn't have an offer for you today, so no, you can't get an offer. Your bond, there is probable cause. Your bond is $250. You can't return to Costco or have contact with any witness in this case. Good luck, sir. I don't know when your next court date will be. Is it in the, does he get it when he bonds out?
Your Honor, state would also ask for no contact with the co-defendant.
Oh, yeah, the code.
All right, no contact with the co-defendant. All right, sir, please tell me your name.
Torianta Foster.
Thank you, sir. 21MM735. You're here charged with trespass and occupied structure or conveyance. Was there an offer, Ms. George?
Yes, Your Honor, the offer was an adjudication of guilt, credit, time served, and no return. I don't have the address, but I know it was Speedway. Do you have the address?
No return to the Speedway gas station located at 13707 West Colonial.
And I did speak to Mr. Foster. We went over all the rights he would be giving up. He understands those rights and would like to accept the state's offer.
All right, sir, raise your right hand, please. Can you raise your right hand? Yeah.
Yes, ma'am.
All right, thank you, sir. You had the opportunity to discuss with an attorney, you can put your hand down, the rights you'd be giving up if you enter a plea of guilty or no contest today. Do you understand those rights?
Yes, ma'am.
All right, did you have a chance to review that form? It further explains those rights.
The nice lady, yeah.
All right. Do you have any questions for me about those rights?
No, ma'am.
You understand that if you're on probation anywhere, this plea could violate that?
I understand to the full.
All right, and you understand if you're not a U.S. citizen, you could be deported?
Yes, ma'am, I know about that.
All right, sir. At this time, how do you wish to plead to trespass in occupied structure or conveyance?
Okay.
I'll accept your plea, sir. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 2 days you've been in custody. Sir, I have to order that you pay court costs. I'm going to give you a year to pay those, okay?
I understand.
And you can't go back to...
The Speedway located at 13707 West Colonial.
Ice coffee. Yeah, I need ice coffee and cigarette.
All right. Good luck, sir. You have 30 days to appeal in writing.
Yeah, okay.
Have a nice day. All right, sir, please tell me your name.
Derek Range.
Sir, you're here in two cases. You have 21MM7658, where you're charged with knowingly and intentionally possessing, unlawfully possessing identification, fraudulent identification, and 21MO1231, charged with possession and consumption of alcoholic beverage in a prohibited place. Was there an offer in these cases?
Not at this time, Your Honor.
All right. Sir, there is probable cause. I'll appoint an attorney to represent you in each of your cases. In the MO case, your bond is $250. You're not allowed to possess or consume any alcoholic beverages. In the MM case, Your bond is $500. No contact with any victim or witness. And at this time, I'm revoking your bond in 21 CF 4751. Good luck, sir. Please tell me your name.
Marie Carballo Ruiz.
20 4475. A capias was issued for your arrest for failing to appear for a hearing on a charge of petty theft of $100 or more. The bond is $10,000. And if you didn't have an attorney, I'll appoint one to represent you.
She has regional counsel.
Oh, that's the email one. Oh, he's not on the line.
And I believe she had an offer to resolve her case.
Well, we can't do that until he's on the line.
Right.
Hold on a second.
Your Honor, are you seeing me online?
Hi, yes.
Sorry, I was on the line. I guess it just wasn't working.
Yeah, and you have a really bad echo, but are you able to hear me? Uh-oh. Mr. Verrett, did we lose you? All right, ma'am, give us one moment.
Yes, ma'am.
Okay, the difficulty should be gone, correct?
Yes, the echo is gone. I can see you. Can you hear us?
Yes, I can hear you, and I want to apologize for not having a tie on. I was told it would be this afternoon, and I don't have one at my disposal. I don't mean to show any disrespect to the court.
No, absolutely. I understand and appreciate that you were able to even appear right now. We decided to start a little bit early, and then we're going to take a lunch break and come back. So you also could have appeared this afternoon, but I appreciate that you were willing to do this.
I'm happy I'm here. Let's get this done. Your Honor, the issue I have on this case is that I received back before she was capious a plea offer from the state. That plea offer was going to be a withhold of court costs. Sorry, withhold adjudication, credit time served, court costs, cost of prosecution, and order reserve on restitution. I've been trying to reach out to the new since then. The states have all switched in that division. I've been trying to reach out to Stephen Pena, who I see would be assigned to that case. I've written him several times over the last couple of days trying to confirm this plea offer. I have not been able to get a hold of him. I don't know if that plea offer is still valid or if Your Honor would offer the same from the bench or what your offer would like to do in this matter.
All right, let me ask Ms. May on behalf of the prosecution.
Your Honor, I did convey an offer. I don't believe a withhold is reasonable in this case, given that she does have prior petty theft convictions. The offer to resolve would be an adjudication, credit time served, and no return.
Were you able to hear that, Mr. Barrett?
Yes, I did. I would advise my client to take it, especially if she would like to get out today.
All right, ma'am, let me have you raise your right hand. We'll ask some questions. Okay.
Yes.
All right, ma'am, you heard what your attorney said.
Yes, ma'am.
And I know this is awkward because you can't have a conversation with him without all of us listening, but is there anything you want to ask him while we're all listening to you and it's on the record?
No, ma'am. I just want to say thank you.
Okay, so Mr. Verrett, I don't know, have you had an opportunity to discuss with your client all the rights she'd be giving up if she entered a plea of guilty or no contest today?
I did months ago.
Okay.
Before the plea.
All right, so ma'am, I'm just going to briefly go through those rights and you tell me if you have any questions about them or if we need to take a recess so you have time to talk to your attorney. So you understand that you're giving up the right to remain silent. You're also giving up your right to testify on your own behalf, your right to be presumed innocent until proven guilty beyond all reasonable doubt, your right to confront and cross-examine the witnesses the state would bring at a jury trial when one is required, your right to call witnesses of your own and have them testify to any defenses that you might have.
Yes, Your Honor.
So you understand we're not doing any of those things. We're not going to have a jury trial here today.
Yes, Your Honor.
Do you have any questions for me about those rights?
No, ma'am.
All right. Also, I'm assuming Mr. Verrett explained to you that petty theft is what we call an enhanceable offense. And what that means is after so many convictions, the state can charge petty theft as a felony.
Yes, Your Honor.
So instead of being a misdemeanor punishable by up to a year in jail, it can become a third-degree felony punishable by up to 5 years in prison. You understand that?
Yes, ma'am.
So I don't know everything about your history, so I don't know how many of these you have,
This would be my third one.
and you don't have to tell me, but I just want to make sure that you understand that because this might count toward that certain number. So if you get arrested for it again, the state might file it as a felony. Do you understand?
Yes.
Understanding all of these rights and having had the opportunity to discuss with your attorney, do you know how you wish to plead today?
No contest is what I would advise her.
Is that what you'd like to do?
Yeah.
Did I also tell you, you understand that if you're on probation anywhere, this plea could violate it?
Yes, ma'am.
And if you're not a U.S. citizen, you could be deported?
Yes, ma'am.
Okay. And at this time, you want to enter a plea of no contest?
Yes, ma'am.
All right, ma'am. I'll accept your plea of no contest. I find it's freely and voluntarily made. I will adjudicate you guilty. Give you credit for the,
Your Honor, I wouldn't have her days because at one point her bond was revoked and I think she was arrested in Adams County
okay.
jail, so I wouldn't really have the exact days that she.
All right, Mr. Verrett, I don't suppose you know how many days she's been in custody?
No, I mean, I know she was brought in, I would think one before, and then I don't know if it counts when she was in Osceola for the last couple of weeks. I have no idea.
Okay.
Whatever it is, we won't object to it, so.
I'm going to order that, I'm going to give you credit for the time that you've been in custody. I can't tell you the amount of days right now, but we will figure that out.
I think I know them.
Oh, you think you know?
Yeah.
How many?
I was in jail last year for this same case and the two petty thefts I had in Osceola from August 19th to November 19th. And I got arrested September 15th and till now of this year.
Okay, we still won't be able to figure it out.
Okay. I'm going to give you credit for all those days. I have to order that you pay court costs and the cost of prosecution. Do you know how long it will take you to pay that?
As soon as I get out, I'll try to go make a payment plan Monday morning or Tuesday.
All right. I'm going to give you a year to pay that
Okay.
from your date of release.
Okay.
Was there any other conditions on that plea offer from the state that
A no return, Your Honor.
no return to where?
It was the Home Depot located at 13121 South Orange Blossom Trail.
All right, ma'am, you understand you can't go back there.
I understand.
All right, and didn't you say, Mr. Verrett, to reserve on restitution?
Yes.
Is there restitution, Ms. May, that you're aware of?
Not that I'm currently aware at this time, so we just ask that you reserve for 60 days.
All right, I'll reserve for 60 days on restitution. All right, ma'am, you understand? Do you have any questions for me?
No, ma'am.
All right, thank you. Thank you, Mr. Verrett. Sorry about the confusion.
No, much. I'm sorry for the confusion. Thank you very much for taking this case. Thank you.
Yes, sir.
Have a great day.
Have a nice weekend.
Bye.
All right. Please tell me your name. 21MM718, a warrant was issued for your arrest, charging you with stalking. Another judge has already found probable cause. I'll appoint an attorney to represent you.
Your Honor, this is another one. I couldn't see the facts. I see the warrant. I don't know what occurred, so.
Okay, hold on, I have the affidavit.
Okay.
No, I don't. I have the warrant.
It's just the, okay.
I don't have any facts to.
Give me one moment, maybe it's on this other thing. That is all I have.
Okay. I didn't know if you had anything. Your Honor.
I usually do, but not in this case. So what says the state has to bond?
Your Honor, the state would be mostly going off of that there was also an injunction involving this same victim, as well as his criminal history includes also a VOP, as well as 2 prior BAT DVs and bad assaults DV. Given the history and that there is a valid injunction involving the same victim.
I believe it was just served on him, the 28th.
Yeah.
Yeah, it was just served on him, so it wasn't, I don't know the facts.
Well, yeah, I'm not saying it was valid at the time of this case, because otherwise he'd be here for a violation of an injunction. But given that there is an injunction with the same victim, that victim is not here to testify today, and he does have criminal history of prior DVs, battery, DV assault, and DV obstruction. State just asked you to take that into account when setting a bond, understanding that it's hard to set it when we don't have a factual basis due to that warrant, and I don't have access to it either.
Your Honor, he was only convicted of a driving while license suspended and a DUI, and that was from, looks like 2006 was the last conviction. Looks like cannabis and paraphernalia.
All right, sir, your bond is $25,000 with special conditions. You can have no contact with the victim. You can't possess a weapon of any kind, firearm or ammunition. You must comply with all conditions in the injunction. Do you understand? Do you understand, sir?
I don't know I'm here.
You're here because a judge issued a warrant for your arrest for stalking. So a judge found probable cause that you stalked someone. That's why you're here. For the injunction? No. Do you have a case number for the injunction, Ms. May?
I could find it, 1 second.
The hearing is. That's what they said.
I believe it is 21 DR 12569.
Your Honor, we would ask, given that my client is unable to post that bond, he is asking for a reduction in the bond amount. Again, I point to the fact that he was just now served this injunction, no convictions for DUI in his history, and I don't know. I mean, I really can't argue because I don't know the facts.
Right. I was actually going to set the bond much higher, so I reduced that amount. But because it's a stalking,
Yes, Your Honor.
I'm not inclined to reduce it any further, but have your office file a motion in front of the trial judge. All right, good luck, sir.
There are allegations within the petition, if you wanted to look at that, on the DR case.
No, I'm just,
But-
I couldn't argue. 'Cause
Yeah, understood. Your Honor, we had a hard stop?
No. Are you okay to keep going?
Oh, for sure.
All right, let's go.
Your Honor, Zaret Alakan, bonded. Marcellus Clark, his behavior.
21 MO 1233. Ms. George, I'll appoint your office.
Can we see if he can be brought back? There was an offer, Your Honor.
And we can bring him back tomorrow.
Thank you.
Philip Harvey has bonded. Keaton Antoine has bonded also.
Oh, I don't have that one. Okay. I say we just see how far we can get, Ms. May.
Agreed, Judge, I just didn't want you to lose track of time if you.
Right, thank you, I appreciate that. All right, good morning, sir. Please tell me your name.
William Norman.
21 MO 1236. Sir, you're here charged with disorderly conduct. Is there an offer?
Yes, Your Honor, I've been authorized on the city's behalf to offer withhold credit time served.
And I did speak to Mr. Norman. We went over all the rights he would be given up. He understands those rights and would like to accept the state's offer here today, Your Honor.
All right, raise your right hand, sir.
Yes, ma'am.
All right, thank you. Mr. Norman, you can put your hand down. You had the opportunity to speak with an attorney about the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, ma'am.
Do you have any questions for me about them?
No, ma'am.
All right, did you have an opportunity to review that paper in front of you?
Yes,
It
ma'am.
further explains those rights.
Yes, ma'am.
All right, do you have any questions about it?
No, ma'am.
All right, you understand that if you're on probation anywhere, this plea could violate it.
Yes, ma'am.
If you're not a U.S. citizen, you could be deported.
Yes, ma'am.
All right, sir, at this time, how do you wish to plead to disorderly conduct?
No contest.
Sir, I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days you've been in custody. Sir, I have to order that you pay court costs. I'll give you a year to pay those. Do you understand?
Yes, ma'am.
All right, good luck, sir.
And thank you, thank you.
Yes, sir, you have 30 days to appeal in writing. Please tell me your name.
It's Johnson Williams.
21 MO 1237. Sir, you're here charged with camping where prohibited. Let me ask, was there an offer?
Yes, Your Honor, I've been authorized on the city's behalf to offer withhold credit time served.
And Your Honor, I would be asking for a bond in this case. He has been scheduled for a comp evaluation in the out on bond case. I would also ask that you take no action on the out on bond. They had to reset this evaluation 2 times with the doctor. We filed a notice of incompetency. And in the camping case, he was merely sleeping on the bench, Your Honor.
Yeah, what says the state as to bond?
Also, I'm a United States judge as well.
Your Honor, state has no objection to staying the bond or reducing it. The out on bond is not the same location as the current case, so state has no objection to also taking no action on that case.
I'm going to release him on his own recognizance. All right, sir, I'm going to release you on your own recognizance, which means you don't have to post a monetary bond today, but I need you to stay in touch with your attorney, okay?
Okay. Okay,
All right, good luck, sir.
No action, Your Honor?
No action.
Your Honor, Julia Kataki, bonded.
Okay.
Mohammed.
This will be yours for tomorrow, since his behavior.
Please tell me your name.
Timothy Mohammed.
Sir, you're here in 21 CT 1884, charged with driving under the influence. I'm going to appoint an attorney to represent you. There is probable cause here. Your bond is $1,000. You can't possess or consume any alcoholic beverages or controlled substances without a valid prescription. Do you understand?
Yes, ma'am.
You can't drive without a valid Florida license. At this time, I'm revoking your bond in 21 CT 844. Good luck, sir.
I have a question.
Yes, sir. Everything you say is being recorded and can be used against you later. Do you understand that? All right, go ahead.
Question is, on this paper, it says $500 bond.
It does. Hold on one moment. Please tell me your name. 17 CT 1805. You're here because a capias was issued for your arrest for failing to appear for court on a charge of expired driver's license more than 6 months. The bond authorized is $2,500.
And Your Honor, the state did offer a withhold of adjudication credit time served. I did speak to Mr. Troy. We went over all the rights he would be giving up. He understands those rights and would like to accept the state's offer here today.
Raise your right hand, please, sir. All right, you had an opportunity to you can put your hand down, to discuss with an attorney the rights you'd be giving up if you enter a plea of guilty or no contest today. Do you understand those rights?
Yes, Your Honor.
Do you have any questions for me about them?
No, Your Honor.
You understand if you're not a U.S. citizen, you could be deported?
Yes, Your Honor.
And if you're on probation anywhere, this plea could violate it?
Yes, Your Honor.
All right, at this time, how do you wish to plead to the charge of expired driver's license more than 6 months?
No contest, Your Honor.
And you said the offer was a,
It was a withhold, Your Honor. It seems like the only thing suspending his license was potentially that DUI that was out of state.
all right.
I don't know the date of that, and given he has no Florida history, I thought a withhold was appropriate.
I'll withhold adjudication, give you credit for the time you've been in custody. I have to, it's what?
3 days.
3 days. I have to order that you pay court costs. I'll give you a year to pay those. Good luck, sir.
Thank you, Your Honor.
You have 30 days to appeal in writing. Please tell me your name.
Honor.
21 CF 14031. It looks like a capias was issued and an information was filed charging you with petty theft with 2 prior convictions. The bond authorized is $2,500. I'll appoint an attorney to represent you. You're not allowed to return to the scene or have contact with any victims or witnesses in the case. Do you understand? All right, good luck, sir. Please tell me your name.
Charlie Brown, 3rd.
21 CF 14027. A warrant was issued for your arrest, charging you with aggravated battery with a deadly weapon. The bond, another judge has already found probable cause. The bond authorized is $30,000. With special conditions, you can have no contact with the victim or any witness in this case. Do you understand what no contact means? You can't possess a weapon of any kind, firearm, or ammunition. Are there any other conditions the state would request?
State would ask for a no return to Emmanuel United Methodist Church located at 701 West Concord Street.
All right, I will order that, sir. You're not allowed to return to that church. Do you understand?
I stay right across the street from that church. I don't attend it at all.
Okay, so just don't go to the church. So I'm not going to order you to stay 500 feet away or anything like that, but I'm saying you can't go to the church. Okay, so if you're home, just don't cross the street and go to the church. Okay. All right, good luck, sir. Sir, please tell me your name.
Ronald Jose Canelon, Your Honor.
21 CF 11642. A warrant was issued for your arrest, charging you with 2 counts of sexual battery on a child under 12 and 1 count of sexual battery with a child ages 12 to 18 by a family member or someone in custodial authority. Another judge has already found probable cause. I'll appoint an attorney to represent you. Ms. May, does the state wish to be heard?
Yes, Your Honor. As to count 1, 2, and 3, all are first-degree felonies punishable by life. Given that, state would ask that you hold him no bond pending an Arthur hearing at a later time.
Anything from the defense?
No, Your Honor, we reserve the right to have Arthur hearing.
All right, I will do that, sir. You'll have no bond at this time. However, even while in custody, you can have no contact with the victim or the victim's immediate family members. Do you understand that?
Yes, Your Honor.
All right, good luck. No, because he's in jail. Yeah, he can't. He's not getting out right now. Please tell me your name.
Jesse Jean Doring.
21 CF 13139. A capias was issued for your arrest for failing to appear for arraignment on a charge of petty theft with 2 priors. I'm going to appoint an attorney to represent you. At this time, you have no bond authorized on that capias. Good luck, sir.
I'm sorry, I was transported from Orange County to Osceola County, and while I was in Osceola County, I was served with the warrant for the felony petty theft. And while I was also in Osceola County awaiting transport to come back to Orange is when the court date occurred for the failure to appear.
So it sounds like you think you have a defense to that. You're going to have to talk to your attorney, and you're going to have to raise that in front of the trial judge. I can't change another judge's capias.
Okay.
Good luck, sir. And then after, this can be our last one right now. We're going to have to break. Right. That one? The last one, the capias. Yes. Please tell me your name.
Sherwin Fraser.
21 CF 14096. Sir, you're here charged with aggravated battery with a firearm. At this time, I'll appoint an attorney to represent you. There is probable cause. Does the state wish to be heard on bond?
Your Honor, state was just asked that you set a reasonable bond. This appears to have occurred due to a road rage incident. I don't believe the victim and the witness potentially know each other. However, it did seem to be like a elongated offense, road rage incident, and then followed her to an unknown location, throwing pennies, kicking the rear bumper, and then getting out, reaching into his waistband and punching the victim, and then arguably pulling a firearm and hitting him in the head. Given all of that, and that it seemed to have been a length of time that he potentially could cool down, state would just ask for a reasonable bond. Also, given that the victim and the witness do not know each other, I believe he has a fairly limited criminal history.
Your Honor, I don't see any history.
I don't either.
Here, he's been in the Orlando area for over a year. He is disputing all allegations. I would ask that you take that he has no criminal history. He has community ties, and it looks like his length of employment has been 21 years at his current job, and that you set bond based off of all of that, Your Honor.
Respectfully, Your Honor, in the affidavit post Miranda, the defendant allegedly admitted to kicking the bumper and admitted to removing his firearm and using it to strike the victim in the head while it was still in the holster.
All right, sir. Your bond is $20,000. You can have no contact with the victim or any witness in this case. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. Did law enforcement secure this weapon? Okay, you don't have it?
No.
Okay. Any other conditions the state would request?
No, Your Honor, but I don't see within the affidavit that it was collected.
Hold on one second. I don't either. But surely they would have collected it at the scene.
Yes, Your Honor, I believe the no weapons, firearms, ammunition would obviously cover this firearm as well.
Right, it does.
As long as Mr. Frazier understands he's not allowed to have this firearm if it was still in his possession or potentially still in his vehicle when he bonded.
Okay. All right. Good luck, sir. Stay in touch with your attorney, okay? Okay. Please tell me your name.
Micah Green.
21 CF 13985. You're here because a warrant was issued for your arrest, charging you with sexual battery. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Does the state wish to be heard?
Yes, Your Honor, as currently charged, it is charged as a live offense. However, after speaking to the sex crimes prosecutor that's going to be in charge of this case, as well as the law enforcement officer that got the warrant, I do believe it was supposed to be charged 5B instead of 5A. 5B is only an F2. That's mostly due to the age of the victim. It's currently charged as under 12. The age of the victim was allegedly 19. Therefore, this should be an F2. Therefore, he is entitled to bond and should not be held no bond. So state's asking for a $50,000 bond at this time.
Wait, which subsection are you saying it should be?
It should be 5B instead of 5A.
All right, I see that the warrant says 5A, but the judge authorized a bond, which I thought was unusual.
Yes, Judge.
All right, Ms. George, did you wish to be heard on anything?
No, Your Honor.
I have an attorney, but I don't know.
Oh, you have an attorney? Do you know who that is?
Philip?
Wait, say that one more time.
Philip?
Philip.
I don't know his last name, but his name is Philip.
Did you hire him? You have to answer out loud.
Oh, yes, I did.
All right, so at this time, are you asking me not to appoint the public defender's office to represent you?
No, Your Honor.
No, you're no, you're not asking me, or no, you don't want the public defender?
No, Your Honor, I don't want the public defender.
Okay, let me see. I don't have anything in the court file from your attorney. Do you know when you hired him?
I hired him on Monday. He's supposed to be here. I called the law office yesterday, and if he wasn't available, then
Welcome to an Econo meeting. You are
one of,
entering the meeting now.
the attorneys from the office were supposed to be
You are the
here to
only
represent me.
participant.
All right, I apologize for that, but I logged into this just in case they were on the link. And I can't stop it from making those announcements when I first log in. I'm gonna give it one more minute. All right, based on the state saying that they believe you should be charged under subsection B, which is a second-degree felony and not a first-degree felony charged punishable by life. At this time, I will set your bond at $50,000 in accordance with the warrant. With special conditions, you can have no contact with the victim or any witness in this case. Do you understand what no contact means?
Yes, Your Honor.
You can't possess or consume alcoholic beverages or any controlled substance without a valid prescription. Are there any other conditions the state would request?
Your Honor, given the nature of the offense, state would also ask for no weapons at this time.
All right, sir, you can't possess a weapon of any kind, firearm, or ammunition.
Yes, Your Honor.
Yeah, and you're not allowed to return to the scene for any reason or be within 500 feet of the victim's residence, school, or place of employment. Do you understand?
Yes, Your Honor.
All right, and I'm going to not appoint the public defender based on his representations here today. But Mr. Green, I'm just going to tell you, you should call your attorney right away, okay?
I was trying to call him today, but I wasn't able to. I only got a chance to call yesterday one time, and I asked multiple times. So
Okay.
I'm trying to get in touch with
Just get in touch with your attorney right away because you do have a bond. So if you're able to post it, you can bond out. But if your attorney wants to file any motions or anything like that, there's not an appearance entered on your behalf yet. So that all needs to be done.
Okay.
Okay, so make sure that you call him right away. Did it say 1,000? No, I just said 500 because of some
I'm
facts
going
in
to be
here.
able to call him after this.
You have access to the phones. I don't know when they'll take you to make a phone call, though.
So with the bond set at $50,000, how much do I need to pay?
So I can't tell you that because that's between you and a bondsman. I don't know what a bondsman will require.
Okay.
So, but that's another reason to call your attorney, or you can start calling bondsmen when you leave court. All right, good luck, sir.
Your Honor, Cynthia Hamilton bonded.
Okay. Please tell me your name. Sean Hamilton? Thank you, sir. 21 CF 13181. You're here, sir, because a warrant was issued for your arrest for violating sex offender requirements. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Sir, your bond on this is $1,000. You must comply with all sex offender reporting requirements. And what is this first appearance detainer?
It's just, he's a high-risk sex offender.
Okay.
It's just something that we do.
All right, but there's nothing else.
No, he has no open cases.
All right. Okay, good luck, sir.
Malcolm Hampton is mental health.
21 CF 14104 and 14105. Ms. George, I'll appoint your office in both of those cases.
I'll waive the appearance, Your Honor.
All right. There is probable cause. His bond is $1,000 on count 1 of 14104. The possession of methamphetamine. It's $1,000. $100 on possession of paraphernalia. $2,500 on the driving while license suspended. Cannot possess or consume any controlled substance without a valid prescription, or have, yes, let's do both, or have contact with any known drug dealers, and cannot drive without a valid Florida license in both. Thank you.
Jordan, bonded.
What about Jewel Joseph?
I'm sorry.
Can he skip Joseph? But he's coming back to that. Please tell me your name.
Joel Joseph.
All right, you have 2 cases here today. In 21 CF 6183, a warrant was issued for your arrest, charging you with robbery by sudden snatching, tampering with a witness to hinder communication to law enforcement, criminal mischief, and battery. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Your bond is $5,000 on count 1, $1,000 on count 2, $1,000 on count 3, and $500 on count 4. With special conditions, you can have no contact with the victim, witness, or any co-defendant in this case. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. Are there any other conditions the state would request in that case?
Just the no return, Your Honor.
All right, no return to the scene. And then in 21 CF 14101, you're here charged with carrying a concealed firearm and providing false identification to a law enforcement officer. I'll appoint an attorney to represent you in this case as well. Ms. George, did you wish to be heard?
No, Your Honor.
Okay. There is probable cause here. Your bond is $2,500 on count 1, $500 on count 2. You can't possess or consume any controlled substance without a valid prescription. You can't possess a weapon of any kind, firearm, or ammunition. You can't have contact with any known drug dealers. All right, good luck, sir.
Thank you.
Jordan, bonded.
Okay.
Martinez Marrero is behavior.
21 CF 9538. I'm going to appoint your office, Ms. George.
I'll waive the appearance, Your Honor.
All right. It's a capias. The bond is $3,000. I'll stay that bond, and I'll take no action on the out on bond cases. Sir, please tell me your name. All right, give me one moment, sir. Mr. McDonald, you're here in 21 CF 14045 because a warrant was issued for your arrest, charging you with sale or delivery of cannabis within 1,000 feet of a school. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. I'm going to stay the bond at $5,000. You can have no contact with any known drug dealers. You can't possess or consume any controlled substance without a valid prescription. Sir, do you live near this school?
No.
Okay, so I'm going to say that you can't go back to that school. That won't be a problem, right?
No.
Okay. I just wanted to make sure you don't tell me that you live there or work there, because I don't want you violating your conditions because you work at the school, but you don't, right?
What school?
Can the state put the factual basis on the record?
1 second, Your Honor.
Hold on, I got to get back into your case. Give me a minute. The warrant says that on or about the 5th day of August, 2021, you were near the H&N Market. Hold on a second.
The school is, H&M Market was across from a park. Hold on a second.
But I need the school. Hey, sir. You would think I would see the name of the school right up front, but I don't see it. What am I missing in this affidavit, counselor?
I don't see it within the affidavit either, Your Honor.
Because another judge signed a warrant.
The last sentence says the closest cross street he was able to call was Gore, and that store was located across from a park. I don't know if that park was attached to a school, but whatever school or park is at Gore and Westmoreland.
Is it supposed to be charged as within 1,000 feet of a park?
It very well may be, Your Honor. I can look to see up that statute, but given it's a warrant, I don't know if Your Honor is able to change it.
It's a warrant, it's not a capias. So if you want to amend the subsection like you did earlier with the other case, you can do that.
Sale and delivery of cannabis within 1,000 feet of a park is 893.13 sub 1 sub 2, sub 1 sub C sub 2.
All right, so, sir, it's not a school, that's an error. It's a park. And it's the park at the corner of Gore and Westmoreland. So I'm just asking, do you live right there? No. Okay, so it's okay. What I'm gonna say is you can't go back to that area. And like I said, I don't wanna set you up for failure, so as long as you don't live right there, don't go back there, okay? Yes. I'll stay the bond at $5,000. Can't have contact with any known drug dealers or possess or consume any controlled substance without a valid prescription. Good luck, sir. Thank you. Right, and another judge has already found it, so I don't want to mess, oh, I signed that one. Hold on one moment, everyone. Oh, that's it. Please tell me your name.
Crystal Morrison.
You're here in 21 CF 14107, charged with possession of cocaine and drug paraphernalia. I'll appoint an attorney to represent you. There is probable cause. In 21 MO 1238, you're here charged with possession and consumption of alcohol in a prohibited place. I'll appoint an attorney to represent you in that case as well. There's probable cause. Your bond on count 1 is $4,000. That's the cocaine. Count 2, it's $500. With special conditions, you can have no contact with any known drug dealers. You can't possess or consume any controlled substance without a valid prescription. And then in the city ordinance case, your bond is $500. You can't possess or consume any alcoholic beverages, and don't return to that area. Good luck, ma'am. Just a moment, sir. Bless you. Please tell me your name.
Mike and Santiago Figueroa.
You're here in 21 CF 14087, charged with burglary of a structure with damage greater than $1,000 and retail petty theft. At this time, I'll appoint an attorney to represent you. Ms. May, did the state wish to be heard?
Yes, Your Honor. State's not asking that you hold no bond. However, count 1 is a PBL as currently charged. However, state's not asking for no bond on this charge, given that it was a residential business and given the amount of the stolen items was approximately, I believe, about $13. However, I just wanted to bring to the court's attention that it is a PBL. Just ask that you set a reasonable bond.
All right. Ms. George, did you wish to be heard?
No, Your Honor.
Can the attorneys approach for a minute? All right, based on the state's position, even though this is a punishable by life offense, the state of Florida is asking the court to set a bond in this case. I'll just ask, Ms. George, did you wish to be heard on bond?
Yes, Your Honor, I would ask that you take into consideration that he has no criminal history, 0 failures to appear, and it does appear that he was stealing food and other items. So I just ask that you take everything into consideration when setting his bond in this case.
Your Honor, in brief response to that, state's concern is his community ties. I believe he told pretrial services that he's been here approximately a week to a month, I believe. So he has not been in the area for a long time. The purpose of bond is to secure the defendant's presence at future court dates. I understand that he has no criminal history to date that we are aware of. However, given that it is a first-degree felony punishable by life and his limited criminal ties, it would just ask for a reasonable bond.
All right, Mr. Pierre, given your no criminal history, and the fact that the state is asking the court to set bond, I will do that. But I want to make sure you understand the way this is actually charged, you could be held at no bond because this charge is a first-degree felony punishable by life in prison. So I want to make sure you understand how serious this charge is. Now, I don't know if the state's going to file this, but I just want to make sure that you understand that. However, I will set bond in this case. Your bond is $10,000 on count 1, $100 on count 2. You can't return to the Family Dollar located at 3015 South Rio Grande Avenue. You understand? You can't have contact with any witness in this case. You can't possess a weapon, firearm, or ammunition. All right, good luck, sir. Yeah. It's right next to me. Please tell me your name.
Felix Planas.
21 CF 14099. You're here charged with possession of fentanyl and resisting an officer without violence. I'm going to appoint an attorney to represent you. There is probable cause here. Your bond is $1,000 on count 1, $100 on count 2. With special conditions, you can have no contact with any known drug dealers. You can't possess or consume any controlled substance without a valid prescription. And is there another, does he have a hold for something? Does he have a fugitive warrant?
Yes, out of Georgia.
He what?
Out of Georgia?
Out of Georgia? All right, sir, you have a warrant out of Georgia right now, so I don't think you'll be able to be released even if you post your bond until that's resolved. All right, good luck, sir. Please tell me your name, sir. All right, Mr. Rhodes, you're here in 21 CF 14024. A capias was issued for your arrest, and an information was filed charging you with petty theft with 2 prior convictions. Your bond is $1,000. You can't return to this location for any reason or have contact with any victim or witness in the case, and I'll appoint an attorney to represent you. Yes, hold on one second. That he can't return to any family, Dollar General? Okay. All right, sir, it also says on the capias that was issued for your arrest, you can't return to the scene of this offense or to any Dollar General. You can't possess or consume any alcohol, illegal drugs, or controlled substance without a valid prescription. You can't possess any weapons, firearms, or ammunition. Good luck, sir. Thank you. Please tell me your name.
Alex Rosa Calcano.
21 CF 14036. You're here because a capias was issued for your arrest and an information has been filed charging you with possession of cocaine. Your bond is $1,500. I'll appoint an attorney to represent you. You can't have contact with any known drug dealers, and you can't possess or consume any controlled substance without a valid prescription. Good luck, sir.
Thank you, man. Have a good one.
You too.
Your Honor, to Jonathan Salazar, bonded.
Please tell me your name.
Ryan Starrett.
21 CF 14106. You're here charged with grand theft of a motor vehicle. I'm going to appoint an attorney to represent you. Ms. George, did you wish to be heard?
Yes, Your Honor.
Go ahead.
My client was charged with grand theft of a motor vehicle. In order to be charged with grand theft of a motor vehicle, the state must prove my client knowingly and unlawfully obtained or used, endeavored to obtain or use the property of another, and he did so with the intent to either temporarily or permanently deprive that person of his or her property or any benefit of it. Here in this case, it appears there is a witness who corroborated my client's statement to the law enforcement officer, who stated when the female arrived with the vehicle, he was inside the house. She asked him to back the car in. He came outside to back the car into the parking spot. He stated at that time he didn't know whose vehicle it was, but he had been homeless and started staying with these people at this residence. And Other than that, there is no evidence that he intended to deprive someone of their property, that he knew or should have known that the property was of someone else's. He merely backed the vehicle in and got out of the vehicle. And the witness actually, again, backed up his statement that he told to law enforcement officers when they pulled him out of the house.
All right, what says the state?
Your Honor, in regards to the grand theft motor vehicle, we do not have any direct evidence. However, the state would contend that we have a lot of circumstantial evidence for a grand theft motor vehicle. We can use the presumption of proof of recently stolen property and just the circumstances within this case. I believe it was a pink-haired female, backed out of the spot, drove to the other side of the parking lot, and then switched spots with the defendant. And then the defendant backed the spot into the same spot, which just arguably is odd. And then the defendant began loading luggage and other items in and out of the Volkswagen. For a grand theft motor vehicle, we had to prove that he knowingly and unlawfully obtained or used or endeavored to obtain or use property of another. Arguably, this vehicle, he did not know whose it was. It had a broken back windshield. Therefore, it would be unreasonable for someone to, one, drive said vehicle, and then two, move items to and from said vehicle. And while doing so, he arguably temporarily deprived the victim of the vehicle. I believe the victim they tried to inform her later. However, we do not have a statement from said vehicle or from said victim. But given the two elements and then the unusual circumstances in this case, it would contend that we do have enough for a grand theft motor vehicle. If Your Honor is unwilling to otherwise find PC, state would ask for 24 hours to try to obtain additional information from the law enforcement officer.
All right, let me tell you guys where I am, and then you tell me where I should be. I read the affidavit. I understand the state can use the presumption of recently stolen property if someone's in possession of recently stolen property. And I also understand possession can be joint, right? So more than one person can be possessing the stolen vehicle. It was stolen. But it seems like the statement by the witness that the woman drove up in the vehicle and then he did move it, that's corroborated. He moved the vehicle. I guess the state can say that's possession.
I believe.
Wasn't there more evidence that she's in possession of recently stolen property than him?
Well, there's several women. I think a woman pulled up with bleached blonde hair, got out of the parking spot, or got out of the car, and then Alexis pulled up with the pink-haired woman who was the one that moved the vehicle with the defendant.
Right. But she shows up, so the woman with bleach blonde hair was sitting in the Passat in the parking lot. Then the other people get in and out. He gets in and out. He moves it. They adjust the seat. They're doing things. Is that enough to say that he possessed the stolen vehicle? Were they all arrested?
I'm not sure, Your Honor, from the affidavit.
From my understanding, it looks like my client was the only one arrested.
Yeah, it doesn't say if they all were, and that's what I'm struggling with. What ties him directly to possessing this vehicle more than other people, including the woman who drove up in the vehicle? Why do we think he possessed it and she didn't?
I believe, or from the affidavit, maybe he possessed more as he began moving luggage and other items in and out of the vehicle after it was parked. It was parked in the parking spot. He then got into the driver's seat, moved out of that parking spot, and then back into that parking spot, and then moved items to and from the Volkswagen.
Your Honor, again, he's inside the house. She goes in. She asks him to move the vehicle, to back the vehicle in. So she pulls up, and then she gets out so he can back the vehicle in. He backs the vehicle in. My client gets out, and the only other thing that he's seen doing is getting luggage from the back of the trunk of the vehicle. based on the statute, Your Honor, I would say that the pink-haired girl is the one that committed the grand theft of a motor vehicle as she pulled up with the vehicle. All my client did, he was asked to back in, which he did. And other than that, which at the very least is a trespass in a conveyance, Your Honor, in this case.
Yes, I don't think you have it, Ms. May.
Understood, Your Honor.
I'll give you 24 hours.
Thank you.
All right, sir, here's what we're gonna do. The state asked for 24 hours to come up with some additional information. I'm going to grant that request. You have a bond of $1,000. I will stay that bond. So you don't have to stay here today. If you can bond out, if you're able to post it, you can. If you're not able to post it, you'll come back tomorrow and see the judge. All right, good luck, sir. Yeah, that one's dicey. Yes. I think I'm just missing something in that affidavit.
Understood, Your Honor.
Maybe the police officer is missing something that.
It's definitely not a standard grand theft motor vehicle.
It's unusual, and I mean, maybe they're all guilty, I don't know, but I just feel like there's stuff missing that we've got to have.
Understood, Your Honor.
All right.
Doc Morton, Jason, his behavior.
All right, 21 CF 14066, 14067, 21 MO 931. Ms. George, I'm going to appoint your office in all of these cases.
I'll waive the appearance, Your Honor.
Was there a competency issue in this case? In any of his out on bonds?
Not that I could see in our system, Your Honor.
Okay, I just didn't know. It's just a lot of things, so I wasn't sure if I was missing that. All right, there is probable cause. The MO case is a capious. It's a failure to appear. His bond is $500. Can I see, what do you have for the bond? Your paperwork? Yeah. Okay, let me get this. Thank you. It's just quicker than clicking. All right, so that, I'm staying that KPS $500. On the 14066, I'll stay the bond at $3,500 on count one, $100 on count two. No return, no contact with any victim, witness, or co-defendant. Can't possess any weapons, firearms, or ammunition. Correct. Yes, there's probable cause for all of them. In 14067, I'll stay those bonds as well. $5,000 on count one, $100 on count two, and $100 on count three. Cannot possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers.
Your Honor, you said 5,000 on count?
Yes. No return to the Wyndham Resort. No contact with any witnesses in the case. And at this time, I'm revoking his out on bond cases. Just give us one moment. Okay. All right. Sorry, that one was a lot of paperwork. Please tell me your name, sir. All right, Mr. Tippins, you're here in 21 CF 14081, charged with principal in the first degree to dealing in stolen property. At this time, sir, I'm going to appoint an attorney to represent you. Give me 1 minute, I'm going to pull up your case in the computer. Ms. George, did you wish to be heard?
No, Your Honor.
I agree. There is probable cause here, sir. Your bond is $2,500. You can't have any contact with the victim, witness, or co-defendant in this case. Any other conditions the state would request?
State would ask for no return to the whatever scrapyard it was, Your Honor.
All right, I'll order that you can't return to that scrapyard, sir. Do you understand? You have to answer out loud.
Yes, ma'am.
Thank you, sir. Sorry, we're making a record so that I can see your head nodding, but the record won't reflect that. So, all right, good luck, sir. Please tell me your name.
Davin Wenzel.
2019 CF 12825. You're here because a warrant was issued for your arrest for violating conditions of pretrial release. I'll appoint an attorney to represent you. At this time, there's no bond authorized. Give me one moment. The allegation, sir, is that you failed to report as scheduled and didn't contact the Office of Pretrial Release, and they had no way to contact you.
Is there no bond authorized on this, Your Honor?
There is no bond authorized. That's correct. All right, good luck, sir. Good afternoon. Please tell me your name.
Everett Williams.
You're here in 18 CF 9515 because a warrant was issued for your arrest and an information was filed charging you with grand theft greater than $10,000 and less than $20,000. Your bond is $5,000. You can't have contact with any victim, witness, or co-defendant. You can't return to the scene for any reason. You can't possess a weapon, firearm, or ammunition. Are there any other conditions in there? All right, sir, you can't return to the Millennium Mall for any reason. Do you understand? The mall at Millennia.
Yes, ma'am.
All right, good luck. Yes. Thank you.
Thank you.
Good luck, sir. Please tell me your name, sir.
Billy Wright.
All right, Mr. Wright, you have two cases here today. 21 MO 1239, you're charged with open container of an alcoholic beverage. There is probable cause. I'll appoint an attorney to represent you. And then in 21 CF 14103, you're charged with possession of MDMA. Again, there is probable cause for that arrest. I'll appoint an attorney to represent you. Your bond on that charge will be $1,000. On the other charge, it'll be $100. Sir, you can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. You also can't possess or consume any alcoholic beverages. Do you understand?
Yes, ma'am.
All right, good luck, sir. Yes. Yes. Because it's the same facts. Sir, please tell me your name.
Robert Young.
All right, Mr. Young, you're here in 21 CF 14079, charged with burglary of a conveyance and grand theft. At this time, I'll appoint an attorney to represent you. Give me one moment, I'm trying to pull up your case in the computer. There is probable cause. Your bond is $3,500 on count one, $150 on count two. With special conditions, sir, you can't have any contact with the victim or any witness in this case. Do you understand? You have to answer out loud.
Yes.
Thank you. See, we're making a record, and the record can't see your head nod, so even though I can see it, I still have to have you answer out loud. You can't return to this scene for any reason. You can't possess a weapon, firearm, or ammunition. Good luck, sir. Oh, no way. Is that everyone? Anything else from the parties before court is adjourned?
Nothing from the state, Your Honor.
Nothing from defendant.